Today's case is a real-life thriller straight out of a crime drama. Christopher Harris, out on bond for a shooting, somehow manages to get arrested again. Just weeks later for a violent armed robbery, all while wearing an ankle monitor. That's right, you heard me. With surveillance tracking his every move, he still pulled off a crime spree, allegedly. And now, in a courtroom that's lost all patience, we watch as the judge dismantles the defense and drops a ruling that leaves no room for debate. Buckle up. This courtroom roller coaster is about to hit full speed.
That's the other document.
He's in custody. Where's Christopher Harris?
They filed a motion to increase the bond.
Christopher, he's in custody. He's in custody.
In the other case.
Okay, hold on. So if he's in custody, why did y'all file a motion to increase the bond?
You already posted a bond of 250,000, and then he got out and
How about he's in custody now? So why is he in custody now? And is the motion to increase bond necessary? I know, is it necessary?
well, he posted 250 before. I'm just concerned that he's gonna believe it needs to be higher than what it is. Based
What
on-
is it right now?
It's I believe
What is
500,000.
Is 500 now? Are you Christopher Harris? Okay, who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000? Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something? It's five, so she posted 50,000. Okay, there's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000.
Let's talk bond. Harris posted a $250,000 bond, meaning someone, in this case his mom, put up at least $25,000 to $50,000 depending on the terms. Then he gets arrested again for a new violent offense, and now the court is deciding whether $500,000 is even enough. What's wild? The defense seems surprised there's a motion to increase bond while the guy's already back in custody. Folks, bond isn't just a number, it's a promise to stay clean while awaiting trial. And when you violate that, the consequences hit hard. Would you risk losing that kind of money for someone you love?
Okay, that doesn't bother you at all? I can see you don't seem real upset about it. It would be for me.
The $250,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is.
That hasn't been
still
revoked yet. That hasn't been revoked.
Correct.
Okay. In 25 CR 1020, Christopher Harris is present with his attorney, Mr. Adams, and the state's attorney. I'm looking at this indictment, which alleges that on or about July 19th of this year, you committed aggravated assault there. And there was a bond set of, it looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right?
That's correct.
Okay. And August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion, they increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
50?
The new one, the 500,000.
The 500 was set by Judge Jerome.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting. And the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So
Here come the details that change everything. The first case wasn't petty theft, it was aggravated assault with a deadly weapon. Harris is accused of entering someone's apartment and firing 6 shots at the victim, hitting them in the lower body. Then he fled the scene. Let that sink in. 6 shots inside a residence. And that's before the second crime. This isn't your run-of-the-mill bad decision. This is a serious act of violence. At this point, the court isn't just considering bond, it's asking, can this defendant function safely in public at all?
and police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont with the lights on and the engine running. And observed someone named Arthur Goulsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson,
This second arrest is where the system's patience officially runs out. Harris, now out on bond, allegedly joins 2 other armed men, lures someone under false pretenses, robs them at gunpoint, and then one of them fires shots as the victim runs away. The getaway vehicle, the victim's own Lincoln Navigator, the cherry on top. Harris is wearing an ankle monitor, so police literally tracked him to the scene. Viewers, how reckless do you have to be to pull an armed robbery while already being tracked by GPS? Drop your thoughts below. Is this stupidity, arrogance, or both?
Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You know, 3 people at gunpoint and then steal everything, tell them to run and then shoot us. Yeah, Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had a ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And they put him right at the location at the time of the robbery. And so If that's not enough, um, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry that was stolen.
Just when you thought it couldn't get worse, police found a video on Christopher Harris' own account showing him wearing the exact jewelry stolen from the robbery victim. Yes, he committed a crime, wore the loot, filmed himself, and posted it. This isn't CSI fiction. This is real life. And it's unfolding in front of a judge who's losing every last ounce of patience. Social media just became Exhibit A question for the viewers. If you're accused of a felony, would you be flexing the stolen goods on ice? Or is this the most self-incriminating post ever?
From the robbery. Okay. There is a motion to increase the bond. Anybody else want to be heard? I've read it, the four corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the woman. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything? Statements?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into it?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bonds? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness, remain in Jefferson County, and 2 test spots.
So just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, and then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious. and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring him did not deter him from committing a more violent crime. So he is in custody, and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people, and to see that the Constitution works, so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond.
And here it is. The gavel comes down, and with it, the judge revokes both bonds, orders Harris held without bail, and calls him a threat to the community. Not just because of what he allegedly did, but because he did it while already out for another violent crime. And the emotional gut, his mother is now out $50,000, and the judge calls her another victim of her son's decisions. Christopher Harris doesn't flinch. No remorse, no regret, just silence. Viewers, what hits harder? The justice system doing its job, or the emotional collateral damage left behind?
And his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost unfortunately to his mother, who posted that bond, but that's the way the rules are. Ironically, you don't seem too upset, but there are victims in two different situations. But there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial.
This case is a brutal reminder that the courtroom isn't just about guilt or innocence. It's about patterns of behavior and public safety. Christopher Harris, charged with 2 separate violent crimes in less than 40 days, lost his bond, his freedom, and possibly his future. And while the justice system acted decisively, we're left wondering, could this all have been avoided if the first arrest led to a stronger intervention? Or was this path already set? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.